Welcome everybody. This is Secure Act 2.0, and it's part of our Haynsworth Sinkler Boyd 2023 Employment Law webinar series. I suspect all of you were expecting me to say that, but in case that isn't what you're looking for, this is what we're going to be doing. Haynsworth Sinkler Boyd is a full-service law firm with 115 plus attorneys and 5 office locations across the Carolinas. I'm in the Greenville office. And for the group, before we get started, if you would like to submit questions, you're welcome to use the Q&A or chat features in the Zoom platform. We'll address as many as we can during the webinar. Similarly, presentation slides and a recording will be shared with you after the event. This course has been submitted for SHRM, HRCI, and CLE credits. And our disclaimers, of course, as always, the presentation is provided for information only and not to be taken as legal advice because all situations are different. You should speak with legal counsel for very specific advice. Did I do that right, Brittany? Okay, you don't have to answer.
Perfect.
All right, good. As a brief overview of the topics for the day, we're going to talk about the Consolidated Appropriations Act of 2023. We're going to talk about 12 major retirement plan changes for your consideration as human resource officers at employers, and how to ensure your business is in compliance. I may mention a few other than 12 if time permits. I'll add, I started this as a blog. When the law passed, I gave it a review, put a blog out, and we thought we would also do this seminar. And as I went back looking through it, I saw more than 12 that might be useful. So if I can throw a few more in, I will do so. But if I'm not able to, the 12 I mentioned, I think are the most substantive. So if we go to the next slide, let's talk about the act. In late December of 2022, they passed the Consolidated Appropriations Act of 2023, which was a supplement to the larger Securing a Strong Retirement Act, and all became law. And this act included a little more than 90 provisions which affect qualified retirement plans. And as is typically the case, somebody comes up with an acronym or a slang term for the act, and this one's being referred to as Secure Act 2.0, which adds to and augments the 2019 Secure Act that was passed that also addressed some of these areas. But this Secure Act of 2.0, Secure Act 2.0 really hit the retirement plan provisions in a big way. And I would submit to you too that the changes that the Secure Act 2.0 passed were all changes geared towards one of these areas, either giving participants more rights and options or encouraging participants to save more. And in some ways, some of the changes give some relief to plans and make it somewhat easier to administer. However, I would tell you that I don't know that they thought about the human resources personnel when they passed this act, because when you give participants more rights and options, you know, somebody's got to administer the new programs, the new choices. You've got to put them out there for people to to choose. So there are some things in here for human resources personnel to, it adds to the plate, and hopefully your vendors will make it easy for you to pass through some of these choices and decision points. But I think when it was passed, it was done so with the intent to help people save and to give people more rights and options. So to that extent, it's a pretty good law. So if you'll go to the next slide. So now we'll begin with our 12 important retirement plan changes. The first one is, I don't know how many of y'all currently administer plans with auto-enroll. If you don't know what that is, auto-enroll didn't exist, say, 10 or so years ago. It was all before 10 years ago, or approximately. People had to sign up to make elective deferrals. There were certain enrollment processes before employees could be forced to make elective deferrals. And a few years back, they came up with the concept of auto-enroll. And what happened when they determined auto-enroll means that the default is, if the employee is lazy and does nothing, under auto-enroll, they will enroll to make a 3% elective deferral each year. And what they determined was that like 60% of all employees are apathetic and don't do anything when the time comes. So before auto-enroll, sometimes participation in elective deferrals would be very low. And after auto-enroll, plans that have embraced auto-enroll sometimes have 80 to 90%, participation rates. So the world at large appears to have determined that auto-enroll is a good thing, and more plans are doing it. So this first new feature directly deals with auto-enroll. And under this new law, a newly created retirement plan that has employee deferral features will be required to contain auto-enroll at a 3% contribution rate. Now, again, with auto-enroll, employees can always log on, and instead of electing to defer, they can elect not to defer, or they can change the number to a different percentage or whatever your plan allows. They can do more or less. But if the employee doesn't feel like touching the keyboard, auto-enroll would start them at 3%. And the way this law was written, if your plan doesn't have auto-enroll and it already exists, it's grandfathered and you don't have to do it. But new 401k plans will have to include it. They will also have to include auto-escalate. There are some exceptions to this rule. New companies that have been in business for less than 3 years, small employers with 10 or fewer workers, they're exempt from having to do auto-enroll. Similarly, a simple 401k is exempt, and government and church plans are exempt from this. So there are some plans that don't have to do that going forward, but new plans, for the most part, will have to include this. Auto-escalate is also going to be required, and under auto-escalate, if an employee does nothing after being auto-enrolled at 3, a year later it goes to 4%. The next year it goes to 5% until the employee actually makes a decision of their own. So I'm looking at the chats just to see if there's anything here. Okay, good. Yeah, and again, this number 1 doesn't apply to government or church plans. Again, the whole point behind this first one is they've determined that auto-enroll boosts participation dramatically. And to the extent a goal is to enable or to make it easier for people to save, that's why this one was passed. It's a push towards more and more auto-enroll. All right. Next slide. All right, the second new provision is the minimum distribution rules. Now, when people are continuing to work past minimum distribution age, they technically don't have to get minimum distributions. But for plan participants who are not working, or for people who have their money in IRAs or whatever, the minimum distribution age has now gone up to 73. It used to be 70 and a half. And the way the law was written, it says in 10 years, it'll go up again to age 75. So I guess the perception was that people are working later, or it's a pro-taxpayer feature that allows people to leave money in a tax-deferred amount for a longer period of time before they absolutely have to begin taking it out. So that's what's happening here. The other thing that this new feature did was they made the acknowledgement that most of the time when people fail to take a required minimum distribution, it's an inadvertent mistake. Okay, it's either that the plan didn't have the age right, or something was done wrong. And so, as part of that tacit acknowledgement that most of the time it's a mere inadvertent mistake, they cut the penalties for failing to take the required minimum distributions. It used to be a 50% penalty. They reduced it to 25%. And the statute also reads that if the mistake is corrected and the distribution made within a certain window, the penalty is only 10%. You've still got the power to request, that the penalty not be imposed, but the penalty, if corrections made timely, which typically it is, reduces the window to reduces the penalty to 10%. Again, this was just an acknowledgement that this operational error usually is an inadvertent mistake, and it happens a lot. So, all right, next slide. So this one's pretty intriguing. I suspect all of you as plan administrators are familiar with catch-up contributions. And what they are is 10 or more years ago, they passed a rule that said for people who are 50 and older and arguably nearing retirement, and maybe have more income than they did in their early days and are now better able to save, it acknowledges that now, well, you may want to put more in, and you're bumping up against the elective deferral limits. So there has existed for a while these catch-up contributions, and what they have done in this statute is increased the catch-up contribution options from $6,500 per year to $7,500 per year, beginning immediately. Also, beginning in 2025, people who are in the age windows of 60 to 63 will have an even larger catch-up contribution opportunity, $10,000 per year. And all of that's pretty taxpayer friendly. Just nobody has to do anything. You can simply put more in. But this third piece here is the part that is intriguing to me, that caught me by surprise. It says that going forward, all catch-up contributions have to be made on an after-tax, like a Roth deferral, on an after-tax basis, unless the individual earns $145,000 or less. So let's boil that down just a little bit. Typically, that wasn't the case, and if you're a human resources manager, your eyes should light up a little bit, because now what you've got to do is monitor this. And if somebody comes in to make a catch-up contribution, then what they can or can't do is based on their prior calendar year's compensation. And if they made $145,000 or less, well, they could choose for it to be Roth or pre-tax. In like manner, if they made more than $145,000 in the prior calendar year, then when they elect the catch-up contribution, it has to be on an after-tax or Roth basis. And that opens up another set of rules too that's kind of interesting, because when you make a deferral on a Roth basis, there's got to be withholding and all that. So I believe the regs will probably give some guidance on how to handle wage withholding in that scenario. But it makes for an interesting decision point, because some people do like Roth, some people don't like Roth, and and it may cause there to be less catch-up contributions because people don't want to pay tax now on money deferred for the future. The other but the message I would give to you is that's another place where human resources personnel will have to make sure monitoring's in place to make sure this gets handled right if somebody makes a catch-up contribution. Also, on simple 401ks, they increased catch-up contribution limits, but not as much as for traditional plans. All right, go to the next slide. Here's another interesting topic. In the first version of Secure Act that passed in 2019, they first brought out this concept that there might be a path where part-time workers have a right to get in your retirement plan. And what the original Secure Act of 2019 did was say that an employee who works between 500 and 999 hours for 3 consecutive years, you've got to let them in to make elective deferrals. You've got to let them in as a participant. What Secure Act 2.0 did is reduce that to 2 years, beginning in 2025. So now an employee who works over 500 hours and less than 1,000 hours for 2 years in a row has a path to get in your retirement plan. I'll note that this doesn't apply to union plans, collectively bargained plans, or it doesn't apply to non-resident aliens. It does apply to 403B plans that are subject to ERISA. But from the human resources personnel standpoint, the intriguing part to me is now you've got to monitor 2 different groups of eligible paths to get into the plan. Is it 1,000 hours in a year that gets you in? Is it, between, if you're over 500, that's a different path. This new law also impacts vesting. If you under this new act, if you get 2 years of this part-time, you can get vesting credit. So I kind of wondered if maybe a lot of plans might just go to a 500-hour methodology just to avoid having to keep track of 2 paths. But I don't know. This is going to be interesting to see how this shakes out. The big takeaway, though, is you can't just ignore people who work 500 or more hours now as part of your processes. You've got to keep track of those hours and make sure that it applies. You asked, does this apply to government plans? I'm pretty sure this does not apply to government plans, because my notes say that 403B plans that are subject to ERISA have to do this, and government plans aren't subject to ERISA. So I strongly suspect, without knowing for sure, that this doesn't apply to government plans, but you may want to check. All right, I'm going to go to the next slide. Beginning in 2024, a plan can choose to make a matching contribution on behalf of employees who make payments on student loans. That one's intriguing, the way this came out. I want to say it was a few years ago, maybe 2018, 2019, somewhere in there. A large employer wanted to do this, and they got a private letter ruling from the IRS that authorized them to make matching contributions based on student loan payments, because in their mind, it was hard for them to make elective deferrals when they're already making big payments on student loans. Well, I guess people figured out, well, if it's good for them, maybe this is an option that all plans might want. So this is not something you have to do. You would have to affirmatively choose to make this a feature of your plan. But beginning next year, if you wanted to do it, you could make matches to a plan based on employee payments on student loans. The things I would mention to you about this that are helpful are that, again, it's not required that you do this. And second of all, if you were to choose to do it, the plan's allowed to rely on certifications made by employees. In other words, you don't have to go to the ends of the earth to confirm that the particular employee made those student loan payments. You're allowed to rely on a special certification by the employee and rely on it. And I'm sure we'll hear more about that, but it's an option for your plan, not a requirement. All right, let's go to the next slide. This one, when I was doing the blog, I thought it was really interesting for people, but it probably applies less to plans than it does to people. But nevertheless, it was one of the 12 I identified, so I left it in here for this discussion. Under the new law, if there's a leftover 529 plan balance, and remember, a 529 plan is a savings plan that that people can set up to pay for college or a private high school or whatever, and they can put money in, sometimes get a deduction, and and when it comes out, it's not taxable if it's used to pay tuition or qualifying educational expenses. Well, apparently they perceived that people, which is a surprise to me, because everybody I've heard of, if their kids paying today's college tuition rates, that money's getting spent pretty fast. But apparently there's a perception that some people had leftover 529 plan balances. And it was a conundrum, because if they didn't have any more education to pay for, when they pulled the money out, it triggers income. And so what they did was pass this law that said, beginning in 2024, if you've sort of, if you've used your 529 plan for what you wanted to use it for education, you've still got money left over, you could take up to $35,000 and roll it into a qualified retirement plan. So that's the message for you human resources people, is that your plans may now receive these types of rollovers. And the rules they have is that the 529 plan has to have been in existence for at least 15 years, which means, which probably factually had to be the case to have a lot of money left over. And that you can't roll over anything that was put in the last 5 most recent years. So that's purpose is to simply prevent people from stuffing a bunch of money into a 529 plan at the end of it and then saying, aha, I'm going to now roll 35 into my retirement plan and get away with it. Hooray. So but subject to those, people now have the ability to roll leftover 529 plan into a plan. So you shouldn't be shocked when at some point somebody asks for this. All right, next slide. So this is similar to some of the topics we brought up during the catch-up contribution topic, is that effective now, an employer can amend its plan to allow the employees to choose that a matching contribution or an employer profit-sharing contribution go to a Roth 401k, so long as the contributions are 100% vested. Previously, the only way for an employee to say, oh, I want money to go into a Roth feature would be, or the primary way was for them to make elective deferrals and to direct it to the Roth. And the employer contributions didn't really have an easy path into Roth. And so, again, following the vein that this legislation is very Roth friendly and Roth favorable, you can amend your plan to make as an option. You don't have to do it, but you can amend your plan to make as an option that employee can say, I want my match to go here, or any employer profit sharing non-elective contribution, that those go into Roth money too, or Roth accounts too. And as I alluded, this is a little more complicated than it appears, because anytime money goes into a Roth, it's not excluded from the employee's income. So once it's in there, future earnings grow tax-free, and it's not taxed when a qualified Roth distribution is made later. But it is taxable when it goes in. So now, if you do this and an employee says, I want the match to go in there, well, that match becomes taxable income because it's Roth to the employee. And you've got to figure out a way to do tax withholding. And again, this wasn't answered by the legislation, but probably will be by regulation. And, how do you communicate this carefully while still letting the employee know the tax implications? I think it's a little tricky. And in like manner, what if somebody's not 100% vested? If they're not 100% vested, can they do it for the vested fraction? It's just a lot of tricky stuff on how to implement this one. So my initial reaction is to perhaps wait to see when we know a little bit more about these mechanics, then decide whether that's something you want to do. But it's effective immediately. And if you wanted to begin to affect it immediately, you'd have to do a plan amendment to bring it in. I'll also mention, while under the vein that I get at, that this applies to, this option is available to 401ks, 403bs, and government 457b plans. So any of those can decide to adopt this amendment. All right, next topic. So at first blush, I thought to myself, well, this is easy. You know, this doesn't really involve HR people. It's just a resource. And it's that the IRS or Department of Labor are going to create, I guess it's the Department of Labor is going to create a retirement plan lost and found database, such that if you've got a lost participant, you're holding money, you can put that information out there and people can go in and search it and say, oh, I've got money here. Okay, that's a good thing. And again, the idea is to let participants look too, so that they can see if there's anything out there that they forgot to claim. This is scheduled to be implemented beginning in 2025. But here's some of the details that have already come out are that the Department of Labor will get this information from the IRS Form 8955-SSA that you, the employers and the plan administrators, are filing along with the annual 5500. So the 8955 SSA should list and should be used by you to report the people who have separated from service and had a benefit still left in the plan. And in my experience, I think plans do a very poor job of listing all the participants on that form who separated and had not pulled a benefit out. So I think there will be heightened awareness, heightened emphasis on getting that information right going forward. So when you're dealing with your 5500 preparers and you're doing all of that, you're going to see more questions about who is separated and left a balance with your plan. The other thing they're saying is on that form, you will have to report people who get fully paid out when they separate from service. So there will be more reporting on that form. Now, again, the hope is that this will reduce the proliferation of missing and lost participants and plans holding money for people they don't know if they're alive or dead or where they are. So that's a good thing, but it just means it's going to put a little burden on human resources to accurately report this information each year as part of the return process. All right, next topic, next slide. So this was, in my mind, a really good thing. They have, and this is a little more complicated than I can do in a short version, but I'll do my best. There has been a whole bevy of information on how to correct operational problems or document problems. And what they're doing here is, by legislation, adding to the list of things that can be simply self-corrected internally by you and your plan, and do not require you to mail anything to the IRS or Department of Labor, like a VCP or other petition where you go, we've made the correction, and here IRS, we're telling you about it. Because I think they felt like the more things that you can self-correct, that VCP puts a chilling effect. People don't want to do them. It's imposing. And so they're increasing the number of things that you can just simply self-correct without a big fuss or a big hubbub. And what they've done is they have said that there used to be some things called eligible inadvertent errors. And if it was insignificant, you could self-correct. And if it was significant, you couldn't. You had to mail something to the IRS. Well, now they're saying if it fell in that category, it doesn't matter if it's significant, which means large in scope, or insignificant, you can still simply correct it. And as long as you do it, yourself, you're fine. You don't have to submit to the IRS. Then there's another category called operational errors, and you can self-correct those even if the IRS catches it first. And you then go, my bad, and you self-correct. And in the past, there was no topic that really, if the IRS caught it first, you could self-correct. So again, there's a lot to this, and the IRS has been tasked with issuing specific regulations on these topics that clarify and explain more. But the point is, there are new and broader opportunities for self-correcting without having to write the IRS or pay a user's fee to do it. Okay. The other kind of really pro-plan, pro-taxpayer thing, this one shocked me, is that one of the big mistakes that happens is plan overpayments. For example, let's say somebody separates from service and you had coded them as 100% vested, but in fact, they were a year short or something like that, and they weren't 100% vested. Technically, if you allowed them to withdraw 100% and roll it over until this, you had a whole mountain of problems. You had, from a plan standpoint, there was a belief that it was a fiduciary breach of the plan, and the plan had to chase the people for repayment. And if they didn't chase them, you were breaching your fiduciary duties and subject to all sorts of problems. And then for the recipient, there was the rule was that anything that shouldn't have been distributed to you technically doesn't qualify for a rollover. So technically, the employee may have rolled it into an IRA or a new plan, but now the part of that wasn't eligible for rollover, so plans had to 1099 people, and the money was it was a horrible mess. And if you've ever had to stick your toe in that water, you know it's a mess. Well, under the new rule passed in this act, the plan can choose whether or not to try to collect an overpayment. And you don't have to worry about adverse consequences like the accusation that you breached your fiduciary duties or any of that, which is a huge, huge relief for plans to have flexibility to deal with the situation. Similarly, the new rule is that if a rollover happened with this inadvertently too big overpayment, it's still a valid rollover for the employee. So that's very pro-taxpayer. And then they have said, if, however, you do choose to pursue collecting of an overpayment, you have a 3-year window to do it. You don't have a duty to recoup earnings, only the exact amount of the overpayment. They're going to tell you some proper communication verbiage. You're not allowed to say, we're going to litigate you into oblivion. There's limits on how much you can talk about litigation. And if an employee believes, no, wait, I should have been 100% vested, and they believe, the decision was right to get the money they got, they have the power to use your plan's claims procedures to contest or dispute what's going on, and your plan through its claims procedures can address the issue. So I viewed all of this number 9 as being very beneficial to the plan and to participants. So that's a good thing. All right, next slide. So this one is pretty interesting. This one is optional for employers, but struck me as kind of a cool idea. Of course, if you were to do something like this, you've got to administer it. But what plans can do now is say our plan will allow non-highly compensated employees to save for an emergency. And what they can do is defer money into a special emergency savings account. It's segregated, not perceived as a traditional plan asset, even though it may be kept with the plan assets. And whatever goes into this emergency savings account can be pulled out by the plan participant at any time, at least once a month. And you can never put more than $2,500 in the emergency savings account. And it can, when they get withdrawn, it's withdrawn without penalty. So what it is it's almost like a little bank account for the employee if your plan chooses to make this available. And it's only available for non-highly compensated, and it grows tax-free while it's in the plan or being held with the plan money. And but if something comes up, the employee, can work his way to saving up to $2,500. And then if, a personal emergency happens, they can pull it out. It's not income to them when they pull it out. And there's no penalty. And it's just, if you choose to do it, it's like you're creating a little savings account for employees. Some of my comments to this are, again, highly compensated employees can't do this. You can set this up for auto-enroll. If you hit the cap of 2,500, it begins to go to, you could have it set up where it goes to a Roth, or you could have it stop. All the monies that go into this are post-tax monies like Roth money. You can't match these. And they made it clear that if you ever set this up and decide you don't like it and you want to eliminate it, it doesn't violate, an elimination of this feature does not violate the anti-cutback rules. So if you were to start something like this up and later decide it's too much of a hassle, you can get rid of it. And then an employee, when they separate from employment, they have a choice of either just cashing it out. And again, since it's not deductible in, not income coming back out, they can either cash it out or they can convert it to a Roth. The other point is they made it clear that if an employee wants to pull the money out, they don't have to show or substantiate the need or an emergency or anything. They can just pull it out. So it's really truly just another pocket bank account that your plan can set up for people. So it's interesting, and I'd be curious to see if many people do it. Next slide. In the same vein, and now we're not talking about these emergency accounts, but we're talking about traditional plan money. And this is an optional feature that's now available for plans. you can establish that participants can make emergency plan withdrawals of up to $1,000 each year when unforeseeable or immediate family expenses arise. And this $1,000 withdrawal is up to $1,000 is not subject to the 10% early withdrawal penalty. You can only do this once in a year. And if you do it, you've got the right, but not the obligation to repay it for 3 years. And if you repay it, you can put it back into the plan. You don't have to. If you do it, you can't do another one for at least 3 years unless you have either repaid it or made contributions to the plan equal to the amount you pulled. So it's a limited ability to make small emergency withdrawals upon a hardship. Now, they expressly state that employees can certify that the need exists. And you don't have to do any more, which is great, which that means you can automate this. And because if the employee certification is good enough, then it can be automated. And that's a good thing. Another optional feature that you may do is to give a withdrawal right for terminally ill participants and for those who are victims of domestic abuse. They sort of deem those as situations where people maybe ought to be able to withdraw, and it's exempt from the 10% early withdrawal penalty. This is not something you have to put in your plan, but you may put in your plan, but it is a good employee benefit that doesn't cost you anything. If you're asking what's terminally ill, they defined it as people who are, this is morbid, but projected to die within 84 months. But they also say that there has to be a distribution event. So people have to have either hit the age they can get a distribution or like 59 and a half or separation from service, whatever it is. And if you have that provision, they also have to be given the right to repay within 3 years if they want to do that. But that is a pro-taxpayer ad you can consider. The effective dates on these vary. The terminally ill provision is available now. The terminally ill and domestic violence option is available now. The other features on this slide are available in 2024 to add if you want to add them. So I'll go to the next slide. Again, another new distribution situation. Disaster distributions are now exempted from 10% early withdrawal penalty as long as no more than $22,000 is withdrawn. Your residence is a federally declared disaster area, and the participant sustains an economic loss. The qualifying disaster distribution, they can, if they take one, they can choose to spread the income over 3 years. They also have the power to repay the distribution like a loan within 3 years. And then they also passed a rule that said borrowing limits, typically there's a $50,000 limit on borrowing. This can go up to $100,000 or if lesser, the vested plan account balance. And longer repayment times for disaster loans are permitted under the new law. So you've got disaster distributions and disaster loans. If you do the loan, you also can suspend repayment for a year till you sort of get out of the disaster. You don't have to immediately begin repaying it like you do with the traditional plan loans. The trick here for you, the plan administrator or human resource person, is that the $22,000 or whatever is a cap per participant. And so you've got to make sure they don't do 22. If you've got more than one plan that your employer has, you've got to make sure they don't do 22 from this plan, 22 from that plan. So that adds some monitoring for the employer and the employer plan. This is only available for defined contribution plans and IRAs who choose to participate. And if they separate from service and decide they want to do a repayment, they can repay to the plan or the IRA or the rollover IRA. So those are my 12, and I'm starting to get treacherously near the end. I will take just a few minutes to reel off, just to tell you of their existence, a few others, and then we'll take some questions. So here are my just a few bonus points for you that I won't go into great detail. One is the 2019 Secure Act provided a tax credit for people who start up plans for the first time, and if you have less than 100 employees. When they did that, the credit was 50% of qualifying costs, and there was an annual credit you could get to for contributions. Under the new Secure Act 2.0, you can get 100% of your qualifying costs to set up the plan as a dollar-for-dollar tax credit. If you have less than or equal to 50 employees, and if you're 51 to 100 employees, it's still the same 50% credit. And again, there's 5 years of additional credits to help fund any employer contributions you make. It's up to $1,000 per employee. You can get a credit for an employer contribution. Year 1, 100%, year 2, 100%, year 3, 75%, year 4, 50%, year 5, 25%. The point is that if you don't have a plan now, maybe it's a good time to start one, okay? Another point mentioned by the new law is you can now give a small de minimis incentive to people who make elective deferrals. So as part of your promotion, if you're having trouble getting people to make 401k elective deferrals, you can give a t-shirt or a coffee mug or a small gift card to everybody who makes an elective deferral if you wanted to, and it doesn't violate, prohibited transaction rules or Department of Labor regulations or all those things. It just needs to be de minimis. I think we probably know what that means. I haven't really explained, but I'm thinking t-shirt, coffee mug, gift card. So let's see, what else did I want to tell you? There's now something called a starter 401k plan if you don't have a plan. That is pretty cool. The deferral amounts are a little less, but they're exempt from testing for the first 3 years. And so it might be a good way to stick your toe into the water on a 401k plan by having the starter 401k and not worry about the testing. Or if you know your highly compensated boss is going to put a ton in and you're worried you never pass the test, this is a way to do it. Also, if you have a simple IRA or a simple 401k program, and you're a small employer, the limits for contributions and deferrals have been increased. So those are my fun new facts from Secure Act 2.0. Does anybody have any questions, comments, or things you want to ask? We've got just about 5 minutes left. If nobody asks, I'm going to regale you with new facts about your audits. Well, not hearing any questions, I will mention just a couple more things. They made clear that, typically your retirement plans have to be audited once you have over 100 participants. They've made it clear that if you're part of a group of plans, like a multiple employer program, where there are lots of employers all sharing one plan, they've made it more easy to participate in that, because now if you have less than 100 in your piece, you don't have to get audited, which is pretty good. And they did a couple of other changes that make it easier for small employers to be part of multiple employer plans. All right, well, that's kind of what I have. If there are any other questions, we do have a few comments we make as we close. Let's see. The next webinar will be Tuesday, April 25th at noon, right around the corner. Chris Gant Sorensen's going to discuss what employers need to know to prepare for the end of the COVID-19 public health emergency. That ends on May the 11th, which is right around the corner. So Chris will share with you what she knows about this topic on Tuesday at noon. And then I guess that's it. Is there anything else I need to say, Brittany? All right. Well, then if that's the case, this concludes our session. Thank you very much for participating. I've enjoyed it, and I appreciate the opportunity to have spoken.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.